Welcome to the Probe's Podumentary. Our Podumentary is a series of audio documentaries on topics and stories that matter to people and are part of our public interest journalism in India. You are listening to me, Prema Sri Devi. Here is a new episode of our Podumentary titled Pending Bail Cases. Do we need reforms or revolution? Justice Sanjay Kishan Kaul, the second senior-most judge of the Supreme Court of India and the executive chairman of the National Legal Services Authority (NALSA), recently said to dispose of the pending bail cases, a revolution was necessary. And out-of-the-box thinking was the need of the hour, as it would take 500 to 700 years at least for the judiciary to dispose them. Justice Madan Lokur, former Supreme Court judge, states that implementing simple solutions like taking up bail cases on priority perhaps can pave way for change.
Well, frankly, I'm not sure why, a revolution is needed to dispose of bail matters. But yes, I think they should be taken up, on priority. You see, there are two kinds of bail applications. One is of a person who is already in jail, undergoing a sentence, and the appeal is pending in a higher court. Then that person applies for bail. I think as a general rule, that case should be taken up on priority because that person has already spent some time in custody. The other thing is that there is no conviction, but the person is an undertrial prisoner. That is the second kind of a bail application. So as an undertrial prisoner, without a conviction, that person is in custody without even being found to be guilty or without being convicted. That person's bail application should also be taken up on priority. From both these categories, the Supreme Court must look into it and, prioritize the bail applications and dispose them off. I think the judges, should appreciate that, bail is the rule. Okay. Don't just take the case of the prosecution at face value, or don't take the case of the investigating agency, that is the prosecuting agency, at face value. They may have their own reasons for keeping a person in custody, but that's not good enough. Since the law is very well settled, I think the judges should go by what the law says. That is one. Second, bail applications should be given priority. It's not that adjourn the matter for 15 days, adjourn it for 30 days. It shouldn't happen. Maybe a day is good enough because personal liberty is very important. The third thing is that, the legal aid system that in our country, that is the state legal services authorities, the district legal services authorities, should be far more proactive than they are at the moment.
Sudhanshu Pandey, a senior advocate with the Supreme Court, underscores the need for tackling the undertrial crisis in India. According to the National Crime Records Bureau, out of the 5.54 lakh prisoners in the country, at the end of 2021, 4.27 lakh prisoners, or 77.1% people, were awaiting trial.
When Justice Kaul has made an observation, he has made observation in respect of both the kind of things, where there are people who are under trials, as also where they are in jail because they have been convicted and their appeals are pending for years together. Problem which we see and the flooding of the dockets of the courts, not only Supreme Court, even the High Courts and other courts, is in respect of cases where there is investigation and during the period of investigation, the suspected accused is put behind the bar, pending investigation or pending trial. You will be very surprised to know that there are cases where under trials have completed the period of sentence for an offense for which the maximum punishment may be lesser than what they have already undergone as a pre-trial in the pre-trial custody. There has been several such cases, starting from Rudal Shah's case, in which Honorable Supreme Court actually created a distinction of sovereign functions. This was a case where this individual, despite having completed the sentence, remained in jail for more than 10 to 15 years. And a compensation was given by the state in that case.
Well, the fact that 76% of the persons in jails or in prisons are under trial prisoners is by itself very unfortunate. I see no reason why it should be such a huge percentage. More than 3/4 of the people in jail are under trial prisoners. There are several reasons for it. One of the reasons is that the courts are sometimes reluctant to grant bail. The second reason really is that priority is not being given to these cases of under trial prisoners. I think if bail applications are taken up seriously and decided quickly, which they can be, there should not be so many under trial prisoners. I think it's very unfortunate.
Bail is one of the most fundamental and critical aspects of the criminal justice system of a country that guarantees an accused the right to a fair trial and protects the fundamental right to liberty of an individual. The two key factors that are kept in mind while granting or refusing bail are to create a balance between individual rights and the interest of society. But in India, bail is highly discretionary and much depends on how the concerned magistrate perceives a case, says Lee Verghese, research manager at Daksh, one of India's leading think tanks and research institutions focused on justice system reforms and access to justice.
Bail is highly discretionary in the current system in India. So, the magistrate who's hearing the bail case, there aren't really any statutory guidelines for them prescribing what criteria they need to use to grant bail. So the routine has become to grant custody and not to grant bail. Secondly, we are seeing a trend of magistrates going into the case itself. The bail hearing is not a trial. You don't have to make a determination on is the person guilty, is the person likely to be guilty, is he likely to be convicted. All that is not the bail magistrate's job. So we are seeing that kind of a trend also. Also, in some kinds of cases, especially involving violence against women, violence against children, there is a lot of public pressure. And so the magistrates are unwilling to face the public anger and don't grant bail. The Supreme Court, in case after case, has said that bail, not jail. That the rule should be bail and not jail. Yet what we are seeing in our trial courts is jail, not bail. The default has become jail. And that's why we have an under trial population of about, I think, more than 70% now. And there is a proposal for a bail bill. I think the union government has proposed it. I think the Supreme Court has also proposed it, but we are not seeing any movement on that. If we have an actual law on bail which specifies, what are the criteria that magistrates should use in case, when under trials are released, how to monitor them, how to ensure that they attend their hearings, the situation may improve.
Many feel that the criminal jurisprudence adopted in India is a reflection of the legacy of the Britishers. One of the most significant drawbacks of the current system is that it does not consider the plight of the poor and marginalized communities. Many believe that the Indian bail system is anti-poor, and this needs to change. Dushyant Dave, a senior advocate with the Supreme Court, affirms that the judiciary must strictly reinforce the legal principle bail is a rule, jail is an exception, which the judiciary across the country has forgotten for many decades.
Most of these people come to the court who have, they are from a very poor background. They don't have, resources to even execute bail bonds, nor do they have, people who can execute bail bonds for them. Coupled with that, I think the real challenge is that the judiciary has been very conservative about releasing people in this country on bail. So I think partly the problem has been created by judges themselves, because bail is a rule, jail is an exception. And that is something which judiciary across the country has forgotten for last about 30, 40 years. Take, for example, anticipatory bail. Now, Constitution Bench of Supreme Court almost 40 years ago said in CBI's case that anticipatory bail should be granted, because you can't just arrest people like that and destroy their image in the society, because many a times these criminal cases are lodged wrongly for out of vendetta, and that judgment is not being followed by trial courts and high courts. And when people come to the Supreme Court and point out that your judgment is not being followed, the Supreme Court remains silent about it. So I think partly the Supreme Court also needs to develop a jurisprudence which is, very crystal clear and with a clear mandate to the subordinate, to the district judiciary and to the high courts, that you must follow this.
Bail is the rule and jail is the exception is a judicial principle that the Supreme Court laid down in a landmark judgment in the state of Rajasthan versus Balchand alias Balia case in 1978. But this cardinal principle is barely implemented, which is why the Supreme Court has emphasized the urgent need for a stringent bail law that lays down guidelines for the disposal of bail applications. Vikas Singh, president of the Supreme Court Bar Association, says there are enough rules in India related to bail, but what we need is proper implementation.
According to me, bail is the rule and jail is the exception. But in India, it is just the reverse. It is jail is the rule and bail is the exception, and which, according to me, that mindset has to change. And that mindset has to change from the lowest of courts. And unfortunately, the way our criminal justice system works, or the criminal jurisprudence works, there is always a element of, I would say, lower court judges feel that if they grant bail, there will be allegations of doing something wrong on them, and that is why they are more reluctant in granting bail. So that mindset has to change, and that mindset will be changed only when the Supreme Court, sermonizes these lower courts to fearlessly grant bail wherever it is due, rather than keeping people in incarceration, mostly as under trials. And even if the sentence has been awarded, and after you've completed half the sentence, then you have a right to again be released on bail if the appeal is not being heard for some reason. Under trial prisoners are remaining in jail many a times more than the sentence for which they could have been convicted. And that's a sad thing in our system. So all that is happening only because of the mindset problem of lower court judges in not granting bail in routine matters. I don't think there is any need to bring in any law. There is already enough bail laws in the country, and it just needs to be properly implemented with guidelines, rather than left to the individual discretion of the judge of granting or not granting bail. So bail is normally considered to be a discretionary jurisdiction, and that discretionary jurisdiction has to be exercised more in favor of bail and less in favor of jail.
The Supreme Court has said in its various judgments that the current bail system in India is discriminatory towards the poor and violative of a person's fundamental rights. In some other cases, rejection of bail on frivolous grounds has violated the individual's human rights. Justice Madan Lokur says Father Stan Swami's case is a classic example.
Famous case of Father Stan Swami, right? He was arrested allegedly because he was in association with persons who were carrying out unlawful activities. There was no charge sheet filed against him. He wanted something like a sipper or a straw because he was suffering from Parkinson's disease. He was more than 80 years of age, and he was unable to get bail, and ultimately he died in jail. I think that was, a very unfortunate, extremely unfortunate case. where I think the system failed him.
The Supreme Court has also said that asking a poor man to furnish an excessive bail amount is as good as refusing bail to him. While this has been a key problem, Sudhanshu Pandey states that even law enforcement agencies must ensure that no one is subjected to arbitrary arrest or detention, and agencies must keep the rights and personal liberties of the individual in mind while attending to cases.
Bail and not the jail. This is the slogan on which any country which follows a liberal principle where the personal liberty has to be paramount. It has to be given priority. Somebody's arrest will impede somebody's personal liberty. So therefore, it can only be done in cases where there is a person is accused of an offense, only and only if there is a fair amount of possibility that the person would be escaping from the process of law and he will be evading the trial. Secondly, the person had so much of resources that he will be able to manipulate the process, witnesses, or issue threat to the witness, and will impede a fair and impartial trial. Arrest is supposed to be resorted to only in respect of these cases where not mere possibility, but where there is a real likelihood that a person will escape the trial. He will flee out of the country, or he may be going and hiding himself in a place where the enforcement agents will not be able to bring him back to the trial, or where he will influence the witnesses or issue threat to the witnesses to not come forward against him. Except for these two situations, during a period when a person is facing a trial and there is a presumption of innocence goes with it, it is very, very unfair to keep him under the custody. Now the question here is that why enforcement agencies are to put a person behind the bar even before commencement of the investigation or even during the investigation.
Solving the issue of the pendency of bail cases needs a multi-pronged approach. According to Lee Varghese, one must look at the trial courts. Lower courts must grant bails to reduce pendency in courts, which will also avoid overcrowding in jails.
Actually, if you want to solve for the issue of pendency of bail cases at the Supreme Court, we have to look at the trial courts, because that's where the bail cases start. People usually approach a magistrate for grant of bail. And what is happening is there's an increasing trend that magistrates are just denying bail by routine. This has kind of become a culture. And therefore, people who are in prison, under trials who are in prison, they need to go to the High Court or the Supreme Court to get bail. In an ideal system, these kind of problems, bail cases should just be resolved at the magistrate's level. They shouldn't be going to the higher judiciary at all. The higher judiciary is meant to look at constitutional cases, appeals where there's a question of law, serious cases. In an ideal situation, such cases would never even be reaching the Supreme Court. But because there is this culture of denying bail at the lower court level, that's why these cases are reaching the Supreme Court.
While the culture of denying bail in lower courts is a problem in itself, the issue related to judges to population ratio has resulted in increasing pendency of cases in courts across the country. According to the government, India has about 21 judges per million people. Dushyant Dave says India's per capita ratio of judges is one of the lowest in the world, and all this also adds up to the piling up of bail cases in courts.
The sheer strength of judges in this country is much lesser than what really should be. Our per capita ratio of judges is one of the lowest in the world. And judiciary doesn't have sufficient infrastructure to deal with so many cases with less manpower, less infrastructure, and the government is not interested in increasing this. So I think the problem has become extremely complex, and as a result of that, we are now seeing today that Supreme Court is flooded with large number of bail applications because the trial courts and the high courts are not performing their duties, sincerely and diligently.